This is part 2 of our documentary on the unclean hands of lenders related to the 2008 mortgage crisis, which triggered a massive economic downturn that many labeled as very close to, if not a great recession. The crisis that began in 2008 lasted roughly through 2014, or about a 6 to 7 year period of economic malaise. In part 1, we chronicled the story of a couple who executed in February 2006 a negotiable promissory note and a security interest in the form of a mortgage during the purchase of their house. This document was filed in the official records of Shelby County, Alabama. The original lender of the promissory note and beneficiary of the mortgage is Hometown Mortgage Services, Inc. Mortgage Electronic Registration Systems, Inc. Hereafter MERS, is not named as the payee of the note, but is named as acting solely as a nominee for the lender as the beneficiary of the security interest or security deed. In part 1, we discussed how the lender in this case, Bank of New York Mellon, BNYM, in their rush to take over the property and kick out the homeowners through foreclosure, prepared and filed a flawed first assignment of mortgage. The flaw was simple enough. The first assignment of mortgage they prepared and filed was to, or in favor of, the Bank of New York Mellon Company, BNYM. National Association FKA, the Bank of New York Trust Company, NA, and not the trust or not as trustee to the trust which owns the note. The reason this is flawed is because to foreclose, the foreclosing party must prove that they own a debt or promissory note that is in default. In this case, the note is owned by the trust, Ramp Series 2006 RZ3, and so BNYM, which owns the mortgage, by virtue of this first assignment of mortgage, has no defaulted note that it owns to foreclose on. What BNYM had was a mortgage with no note. And what the trust had was a note with no mortgage, collateral or security, essentially a personal or unsecured loan. On this part 2, we will tackle the validity of second assignment of mortgage, do-over of the flawed first assignment of mortgage. On February 21st, 2023, or 13 years after they prepared a fraudulent first assignment of mortgage, BNY Mellon, BNYM, fabricated a second assignment of mortgage. So what BNYM is trying to do on the second assignment of mortgage is to assign to itself the mortgage as trustee of the Ramp Series 2006 RZ3. This amendment or change that the mortgage being assigned to BNYM as trustee of Ramp Series RZ3 was absent in the first assignment of mortgage. There is one problem with this second assignment of mortgage. It is based on a falsified and fraudulent and void first assignment of mortgage. Having falsified and illegally manufactured, in collusion with MERS and misrepresented and concocted the participation of GMAC Mortgage, GMAC, through a fictitious signature without GMAC's knowledge, the original assignment of mortgage recorded on 2/6/2010, which is the basis of BNYM claim of ownership of the mortgage, is null and void. That first assignment of mortgage was an exercise in fraud. The people purportedly representing MERS did not have the required legal authority and were falsely acting on behalf of MERS. The documents they attached to the first assignment of mortgage were doctored and falsified as follows. P1. MERS is acting as nominee for Hometown Mortgage, which does not own the mortgage. The mortgage is technically owned by GMAC, which funded the loan. Yet there is no document on file which shows that Hometown Mortgage transferred the mortgage to GMAC. Hometown Mortgage, while being the mortgage broker, is listed as the owner of the mortgage. 3.2. The signing agreement for signing and referred to as Exhibit A is from GMAC, not Hometown, yet MERS is indicating that they are acting as nominee for Hometown Mortgage. 3.3. Colleen McCulloch signed as Assistant Secretary and Vice President of MERS. She is an employee at the time of Sirote and Permut, and she has no valid authority to sign for MERS. 3.4. There is no signing authority from Hometown Mortgage, and thus C. McCulloch had no valid authority to sign for MERS as nominee for Hometown Mortgage. It might also be that they are trying to keep a distance to their criminal liability in falsifying and fabricating documents related to the first assignment of mortgage recorded on June 7, 2010, which was contrived between Mortgage Electronic Registration System, MERS, and BNYM on June 7, 2010. This first assignment of mortgage used fabricated and falsified signing authority, falsified signatures, and falsely involved GMAC mortgage, which was not a party to the transaction. 7 days after BNYM falsely claimed ownership of the mortgage based on a fraudulent first assignment of mortgage, BNYM filed an illegal foreclosure on March 1, 2023. Why the foreclosure action was flawed and illegal? 1. The foreclosing party, or the holder of the securitized note, Trust Ramp Series 2006 RZ3, Trust, did not own the mortgage or the security for the note. The trust, where the mortgage note was securitized into closed on August 3, 2006. According to the Pooling and Servicing Agreement, PSA, of the trust, no more assets can be added to the trust after it closed. Thus, the trust does not own the mortgage security for the note, and what it has is essentially an unsecured note. It certainly owns the mortgage note. In the case Harris vs. Deutsche Bank National Trust Company, Ms. 111-54, September 13, 2013, the Alabama Supreme Court discussed the issue of a party that does not hold a promissory note to execute a power of sale in a mortgage. Here, the borrowers executed a note and mortgage in favor of South Star Funding, with MERS as the lender's nominee. The borrowers defaulted, and after MERS assigned the mortgage to Deutsche Bank as trustee, Deutsche Bank conducted a non-judicial foreclosure. The bank filed an eviction action, and the borrowers defended by challenging the bank's power to foreclose. The Alabama Supreme Court held that a party is entitled to foreclose if it is a party who, by assignment or otherwise, becomes entitled to the money thus secured. However, the court was unable to reach a decision on whether Deutsche Bank was the party entitled to foreclose and remanded for review. The safe way to proceed in the future, then, is to ensure that even if there is an assignment of mortgage, servicers should make sure to also have the note in their possession, either endorsed in blank or into the foreclosing entity. In this, our documentary, the first assignment of mortgage was flawed, fraudulent, and null and void, and thus the second assignment of mortgage, which is based on the first assignment of mortgage, is also null and void. Bank of New York Mellon is not the party entitled to foreclose, as it did not own the mortgage note and did not endorse the mortgage, the security, to the trust that owned the note. 2. Assuming, for argument's sake, that the first assignment of mortgage was not null and void due to fraud, and the second assignment of mortgage was based on a legal first assignment of mortgage, BNYM, as a separate and distinct legal entity from the trust, Ramp Series 2006 RZ3, owned the mortgage, security, but it did not own the note. The trust, another separate legal entity registered with the Securities and Exchange Commission, owned the note. Let us not forget that there are two separate legal entities here. 3. BNYM cannot foreclose on the mortgage, security, without an underlying debt obligation or note which is owned by the trust. 4. And the trust cannot foreclose because it did not own the mortgage or security. And it is too late for BNYM to endorse the mortgage to the trust, as the trust closed on August 3, 2006. What the trust had essentially was an unsecured mortgage note or loan. 5. If BNYM's intent is to endorse the note to the trust, then it has to follow the chain of endorsement required under the trust's PSA, from the originator to sponsor, from the sponsor to the depositor, and then from the depositor to the trust. It does not appear that this required chain of endorsement was done here. Even this is moot, because, again, the trust closed on August 3, 2010, and no more assets can be added to the trust after it closed. This fatal flaw or omission was also not done in the first assignment of mortgage. 4. Again, we need to strongly stress that BNYM never acquired ownership of the mortgage, security, due to the illegal and fabricated first assignment of mortgage. 5. The naked falsification and fabrication of records, doctoring and falsifying, assigning authority and falsification of people's signatures on the first assignment of mortgage perpetrated by BNYM, MERS, and other actors are criminal acts that should be prosecuted. These criminal acts of fraud rendered the first assignment of mortgage null and void. Thus, the foreclosing party, the trust, cannot foreclose because what it had was essentially an unsecured note, the mortgage note. The trust did not own the mortgage. BNYM did, Again, assuming the first assignment of mortgage was not fraudulent. And BNYM, as a trustee of the trust, cannot foreclose on behalf of the trust for the same reason, and that is there is no mortgage or security for the trust's note, essentially an unsecured loan. BNYM never endorsed it to the trust before the trust closed, and BNYM by itself cannot foreclose because it has no note to foreclose on. The note is owned by the trust, not BNYM, not to mention BNYM never acquired ownership of the mortgage, security, because the null and void first assignment of mortgage. On Part 3 of this three-part series, we will discuss the bankruptcy of GMAC, General Motors Acceptance Corporation, in 2012. GMAC is the capital source and buyer of the mortgage note in this case. We'll discuss the implications of its bankruptcy to the thousands of high-risk mortgage loans that they bought from hundreds if not thousands of mortgage brokers and securitized them as MBS during the turbulent and chaotic 2008 mortgage crisis. BNYM is double-dipping, and we will review the $8.7 billion 2012 New York bankruptcy filing of ResCap, Residential Capital, a subsidiary of GMAC, that essentially settled the claims of hundreds, if not thousands, of MBS trusts, one of them being the trust in our documentary Ramp series 2006 RZ3. BNYM, the trustee for 2006 RZ3, admitted having received hundreds of millions of dollars from the bankruptcy settlement. Yet despite having received hundreds of millions of dollars, BNYM continues to immorally double-dip by going after this property whose mortgage note has essentially been paid off through this $8.7 billion bankruptcy settlement.